What's up, guys? Brian Fell, Fell Law Group PLLC, here with your Florida Law Weekly case update. Only got two cases for you this week. It's a relatively light week, but still some interesting cases to go over. The first one is Delosreyes versus Delosreyes. It's out of the 4th DCA. It has to do with imputation of income in a child support case. And so, unlike in an alimony case where the new alimony statute specifically allows the court to take into consideration investment income from, let's say, a party receives a sizable equal distribution award, the court can take into consideration potential investment income on that equal distribution. However, for the child support statute 61.30, they don't have that same language. So in this case, the trial court imputed income to the former wife based on investment income. So basically, her forensic accountant, I'm sorry, the husband's forensic accountant testified that she could earn 4% on about $1 million in stocks that she had. And the appellate court reversed for a multitude of reasons. First of all, they said under the child support statute, in order to do that, you'd have to show that the wife is voluntarily unemployed or underemployed. And the court obviously did not do that because it wasn't a case of being unemployed or underemployed. It was just an imputation of income on her investments. So in child support, you have to actually have findings of unemployment or underemployment in order to impute on investment income. But even still, there's really no mechanism in the child support statute to allow the court to do that. The court can take into consideration for income purposes actual interest and dividends received, but they really can't impute income on this basis. So that's something interesting. Maybe the legislature will end up amending the child support statute to allow the court to take that into consideration because it makes sense. But at least at this point, 6130 does not allow you to do that. The other thing I thought was interesting was the former wife in this case tried to have the court impute income to the husband, but she did not plead for it, which is also interesting to me because you think of a divorce petition, you don't always specifically plead to have the court impute income to the other party if they're unemployed or underemployed. But here, the former wife did not plead it at all. So if you really want to impute income to the other side, make sure you put that in your pleadings. So that's something to be aware of. And the last thing in this case that I thought was interesting was the court basically affirmed the denial of retroactive child support for a particular period. The wife was asking for retro, and the court denied it for a few months, where the court said that she did not have the need for retroactive child support. I thought that was interesting because you don't really see that in the statute 6130. It doesn't really specifically talk about you have to show a need for retroactive child support. In the statute, it really just, this is section 17 of the statute, it really basically says, apply the child support guidelines. You can go back 24 months, apply the guidelines, and take into consideration any actual payments that were made during that time. It doesn't really say you have to show need, like as if this were an alimony case. But the court found that because of the wife failed to demonstrate she had a need for retroactive child support for those couple months, that the court was within its discretion to deny her retro for that period. So 3 interesting things in that case. The next one is McPherson versus Samuel. This is another one out of the 4th DCA. This has to do with an injunction for stalking. The only thing I thought was interesting was this is a reminder of when to allow for a motion for continuance to be granted. And I see this all the time where people ask for continuances, but they really don't go into the actual factors that the court considers for granting or denying a continuance, which are, number 1, whether there's going to be injustice to the party that's seeking the continuance. Number 2, whether the need for the continuance was unforeseen or was it due to delay or dilatory actions on the part of the party seeking the continuance. And number 3, whether the other side would have been prejudiced by a continuance. In this case, the person asking for the continuance, she was going out of town. This is the person against whom the injunction was entered. She was out of town. She was internationally traveling, and she asked for a continuance like the very next day after she got served with the domestic violence temporary injunction. And so there was really no basis to deny her motion for continuance. But just a reminder to go through the factors. Each time you ask for a continuance or if you're defending against a continuance, go through those specific factors to show why the court should grant or deny it. Because sometimes people just use equity or things like that, but really you should ask for a continuance or defend against a continuance based on the factors that the court considers, which are, again, injustice to the person seeking the continuance, whether the continuance was unforeseen or dilatory, or and also whether the other side would be prejudiced by a continuance. All right, guys, that's it for this week. Good luck to everybody who has kids going back to school next week, and I will see you then. Take care.